The International Criminal Court is now in session.
Thank you, Ben Clark. Good morning to all of you. Welcome to this sitting. I would like to start with introduction of the panel. The panel is composed of Judge Natalie von Wistinghausen, Judge Christoph Safferling, Judge Joanna Korner, Judge Christoph Barthe, and I'm Judge Ivana Hrdličková, presiding over the case. I would like to ask now the parties to state their appearances and indicate how they would like to allocate the pleading time, starting with the prosecution, please.
Good morning, good evening, good afternoon, Madam President, Your Honors, members from the Defense Council. It's an honor to appear before this bench representing Koç University from Istanbul, Turkey. My name is Özge Karsu, and alongside with my co-counselor, Mr. Ashula, today I will be speaking on behalf of the Office of the Prosecutor. Today, first, Mr. Ashula will cover the issue of admissibility, and he will speak for about 8.5 minutes. Then I will cover the issues of jurisdiction and superior responsibility of Mr. Gravus, and I will speak for 16.5 minutes. We would like to reserve 5 minutes for the rebuttal. Thank you.
Thank you very much. Now the defense, please.
Good morning, Madam President, Your Honors, and of course the Office of the Prosecutor. My name is Dylan Jesse Andrian, and along with my co-counsel, Ms. Nicole Binder, we plead on behalf of the defense. I will speak for 15 minutes and Ms. Binder for 10 minutes. Thank you.
Thank you very much. Now we will start hearing the parties and we will start with the prosecution. So the first speaker, please, the floor is yours.
Thank you. Madam President, Your Honors, may it please the court. My name is Muhammed Dizderevich Ashula, and I will be pleading on behalf of the Office of the Prosecutor, the OTP. Today, we will show on reasonable grounds that the case is admissible, the court has jurisdiction, and Mr. Gross is criminally responsible. I will focus on admissibility and speak 8.5 minutes. My co-counselor, Ms. Karsu, will cover other issues. We reserve 5 minutes for rebuttal. The present case involves Castarians who are victimized. Castarians were oppressed by an authoritarian government for generations. They only tried to take their freedoms back. However, they were labeled as terrorists. They were killed, assaulted, and worse, were forced to live under the terrible conditions imposed by the military regime. Justice for the victims and for Mr. Grover cannot be achieved by a military court established by a putschist general against another one. As confirmed by this chamber in the decision on the admissibility challenge in Saif al-Islam Gaddafi case, paragraph 32, the burden of proof in admissibility lies with the challenging party, the defense. They have to demonstrate that Hanatun is willing and able to conduct an investigation. Most importantly, as confirmed by that decision, as well as the appeals chamber's Kenya admissibility decision, paragraph 61, the evidentiary standards in the particular issue is evidence of a sufficient degree of specificity and probative value. Under Article 17 of the Rome Statute, for a case to be admissible, the case must be of sufficient gravity and the principle of complementarity must be satisfied. Now, I will turn to the first issue. The case is of sufficient gravity as required by the Article 17(1)(d) of the Rome Statute. The gravity of the case evidenced by the Security Council's referral of the situation in Hanatun. It is also supported by other elements such as the leadership rank for perpetrators, the extent of damage caused, in particular, the harm caused to victims and their families, the number of victims, as well as other qualitative factors as indicated in Abu Garda case. To give a glimpse of the facts, 200 Castarian men were shot dead when they resisted arrest, and 150 female Castarians, among them girls aged between 13 to 24, were arrested. 86 male companions were shot in the head. The girls were taken by the SPG to different stations where they were forced to cook, and provide sexual services so that the SPG officers would not kill them. Police department forced all local businesses to close and warned them not to reopen. All roads to Casteria were blocked, and this blockade caused a famine throughout Casteria. Even the images from the social media, the dead bodies of women and children on the streets demonstrate the gravity of this case. In light of these facts, the fact of famine increases the gravity from a qualitative perspective. Therefore, there are reasonable grounds to believe that the gravity threshold under Article 17(1)(d) of the Rome Statute is met in the present case. Now, I will turn to the second issue. The principle of complementarity is satisfied since Hanatun is unwilling and unable to genuinely carry out the investigation or prosecution. The very first article of the Rome Statute provides that the ICC is a court of complementarity. The ICC only acts when the state is unwilling or unable genuinely to carry out the investigation or prosecution. The principle of complementarity balances the ICC and the state party's jurisdiction. The purpose of the principle of complementarity is to protect a state sovereignty, not the individual rights of the accused. Why is Hanatun not challenging admissibility if it is indeed willing and able to prosecute? If Hanatun did, the OTP would have deferred to national courts as per Article 18(2) of the Rome Statute. In Mutahara, Kenyatta, and Ali case, the appeals chamber defines the terms unwilling and unable as the state having jurisdiction and has not done the investigation with mere investigative steps. In the case, Hanatun was unable to investigate or prosecute since the military intervention harmfully affected the governmental and judicial system twice in 6 years. It is important to state that the conflict in Casteria drew near to civil war. Importance of the situation is the fact that it affects the judicial system and it has been harmfully affected. Accordingly, there is neither judicial independency nor such an institutional ability for such an investigation. This shows that the government is not able to prosecute since the institutions of the Republic faced damages after the change in regime in twice. Indeed, mere existence of an investigation or prosecution is not sufficient to challenge admissibility. They should also be genuine. In order to determine an investigation as genuine, the state should use all the legal means at its disposal in the conduct. The state should declare its own intention to bring the accused person to justice by a serious criminal process in which the suspects will face an actual trial and an appropriate punishment if necessary. In the present case, Hanatun was not acting genuinely. The military court was only established after the concrete and continuous pressure from international community and human rights organizations. Furthermore, it is not sufficient to merely assert that the investigations are ongoing. Indeed, there is no single information or evidence in the case file which shows that the military court actually, in fact, started the investigation. There must be a clear and convincing evidence that the investigation has started. The fact that several high-ranking military officers have recommended Mr. Gravus's release also support this conclusion. As a result, there are reasonable grounds to believe that the Hanatun was unwilling and unable to genuinely investigate or prosecute under Article 17(1)(a) of the Rome Statute. The ICC, in the present case, is required to take action since the national criminal jurisdiction is unable and unwilling to have an effective prosecution. Unless I have further assistance to this pre-trial chamber, this concludes my submissions. Now I will yield the floor to my co-counsellor, Ms. Kars. Thank you.
Thank you very much, Ms. Kars. The floor is yours.
Thank you. Madam President, Your Honors, may it please the court. My name is Özge Karsu, and I will be pleading on behalf of the OTP. Today's case involves the destruction of the very essential foundations of the life of Castrians. It involves hundreds of victims who faced atrocities that shocked and disappointed the notions of humanity. It involves the need for this court to put an end to impunity for the perpetrators of the crime of crimes, the crime of genocide. Today, before this pretrial chamber, I will show that there are reasonable grounds to believe that the court has jurisdiction and Mr. Gravos is criminally responsible. Now I will start with the second issue, jurisdiction. The situation in Hanatun was referred to the OTP by the United Nations Security Council as per Article 13, paragraph B of the Rome Statute. Accordingly, only two grounds of jurisdiction must be satisfied: temporal jurisdiction and subject matter jurisdiction. I will now start with temporal jurisdiction. Under Article 11, paragraph 1 of the Rome Statute, the court's jurisdiction is limited to the crimes that were committed after the entry into force of the statute. The court has temporal jurisdiction in the present case, since the acts were conducted after 1 July 2002. Now I will move to subject matter jurisdiction, and I will present my arguments in three main parts: the material elements, the mental elements, and the contextual element of the crime of genocide. Starting with the material elements. The acts in the present case include the conduct of killing and inflicting certain conditions of life on Castrians calculated to bring about their physical destruction. I would like to remind this pretrial chamber about the acts directed against the Castrians. During the house arrest, 200 Castrian men were shot to death. 86 Castrian were shot in the head at the airport, and 150 female Castrians were arrested. The girls between aged 13 to 24 were taken by the SPG to different stations where they're forced to cook and provide sexual services. And further, there was a blockade which resulted in famine and caused a significant risk to their physical existence. These acts were conducted by the security forces, the NDS, SPG, and the police department, and the target was Castrians, which constitute an ethnic and religious group. A case of trial chamber in paragraph 515 defines the term ethnic group as a group whose members share a common language or culture, and the religious group as a group whose members share the same religion, denomination, or mode of worship. Castrians share a common language called Otati, and they have the same worship as they believe in a god called Otsare. Further, as confirmed by the Christoph trial judgment in paragraph 557, a group's characteristics must be identified within the social historical context. As stated in the case facts, in paragraph 4 and onwards, Castrians, as an ethnic minority, have been oppressed for more than 100 years, and even they were resettled in the region of Casteria, a province in the middle of Hanatun. Even though clarification 1 states that the term Castrians refer both to ethnic minority group and the general population, the target in the present case was Castrians as an ethnic and religious group. Now I will move to the mens rea requirement of the crime of genocide. There was the intent to destroy Castrians in whole or in part. As confirmed in the Bilagozevic and Jokic judgment in paragraph 686, specific intent of the subordinates shall be demonstrated in this case for subject matter jurisdiction. In the present case, the subordinates, the security forces, had the specific intent to destroy Castrians. As stated in the elements of crimes, the existence of intent and knowledge can be inferred from relevant facts and circumstances. The ICTY stated several factors which can show the existence of specific intent. These include the existence of a plan or policy the perpetration of acts systematically directed against the same group, the scale of atrocities, the repetition of the acts, and systemic targeting. Now, I would like to direct this pretrial chamber to paragraphs 13 and 15 of the case facts, which indicate the specific intent of the security forces. First, as stated in paragraph 13, during the searches, the SPG forces were calling, and I quote, "Castrians are cancer," end of quote. Second, the NDS released Mr. X when they recognized that he was not a Castrian, but belonged to Hanu ethnicity. But at the very same night, they killed 200 Castrian men. And third, as stated in paragraph 15 of the case facts, the police department conducted a blockade in Casteria, which is predominantly home to ethnic Castarians. These facts demonstrate that the acts were directed against Castrians because of their group identity, with the intent to destroy them in whole or in part. Lastly, I will talk about the contextual element of the crime of genocide, the existence of a manifest pattern of similar conduct. This requirement is neither stated in the Rome Statute, nor is a requirement under customary international law. Elements of crimes, which the court applies in the first place under Article 21 of the Rome Statute, requires such an element. The acts in the present case took part in the context of a manifest pattern of similar conduct. The oppression against Castarians started more than 100 years ago, and then it continued with reducing the federal payments and preventing Castarians from taking positions in the government. Then the counterterrorism campaign gave power and authority to the security forces to destroy Castrians. It directly named Castrians as supporters of terrorism, and it further stated that the campaign has long-term purposes. There was a concrete threat to the existence of Castarians. The acts had a nature that led to at least partial destruction of them. The threat was concrete and real. Accordingly, the OTP submits that there are reasonable grounds to believe that the court has jurisdiction in the present case. Madam President, Your Honors, I will now move to the third and last issue, superior responsibility of Mr. Gravus. In the Bemba case, the pretrial chamber stated that in order to prove criminal responsibility within the meaning of Article 28, paragraph A of the Rome Statute, 5 elements must be fulfilled. Individual criminal responsibility of Mr. Gravus will be examined in these 5 consecutive parts. First, the OTP invokes Article 28, paragraph A of the Rome Statute, since Mr. Gravus is a military commander. The chamber defines the term military commander as a category of persons who are formally or legally appointed to carry out a military commanding function. This is irrespective of the rank and also includes superiors who do not exclusively perform a military function. Mr. Gravus was the president and commander-in-chief of the armed and security forces since August 2016, as can be seen in case facts paragraphs 6 and 7, and he was holding this status during the commission of the crime. Now I will move to the second element. Mr. Gravus had effective authority and control over the subordinates. Effective authority requires the material ability to prevent or repress the crimes, or the ability to submit the matter to competent authorities. This court determined several criteria to indicate the existence of control on the basis of evidence. Accordingly, the official position of the accused, the power to issue orders, and the capacity to ensure compliance are indicators of effective control. In this present case, Mr. Gravus was the president and commander-in-chief. There was a hierarchical relationship between Mr. Gravus and the security forces. As stated in the orders of the counterterrorism campaign, in paragraph 11, subparagraph E of the case facts, heads of all 3 security divisions report personally to the president. And as shown in Exhibit 1, there is a direct communication between Ms. Jolie, head of the NDS, and Mr. Gravus. In this text message, Mr. Gravus said, and I quote, "Please report to me any security-related threats," end of quote. This demonstrates that there is constant communication between them, and Mr. Gravus wanted to get reports regarding every security threat. Taking and implementing orders within such a communication and reporting system demonstrates effective authority and control of Mr. Gravus. I will now move to the...
Council, may I interrupt you briefly? Could you please explain us if the accused had a real control over the behavior of Ms. Jolie and the security forces? And if he didn't, does it change his criminal responsibility or not?
Madam President, for a superior to be held responsible under Article 28, paragraph A of the Rome Statute, there must be an effective control and authority over the subordinates. And in this present case, we would like to demonstrate that Mr. Gravus had effective authority. For this, we are relying on the indicators of effective control that was confirmed by this court in the Bamba case. So accordingly, Mr. Gravus was the most senior official in the Republic of Hanatun, and he had the power to issue orders to Ms. Jolie. And also, as stated again in the orders of the counterterrorism campaign, heads of all 3 security divisions, including Ms. Jolie, had a responsibility to personally report to the president. All these facts combined demonstrates that there are reasonable grounds to conclude that Mr. Gravus had the effective authority and control over the subordinates, including Ms. Jolie.
Thank you.
Thank you. Now I would like to move to the third element. Mr. Gravus knew or should have known that the forces were committing or about to commit the crime of genocide. As confirmed by this court again in the Bamba case, the suspect's knowledge can be obtained by direct or circumstantial evidence. The court stated that there are several factors which indicate the existence of knowledge. These factors include the number, type, and scope of the acts, the time the acts occurred, the type and number of forces involved, the commander's position, and the means of communication. In this case, firstly, the position of Mr. Gravus and the communication system between him and the security forces are important indicators of knowledge. Second, all 3 security divisions were involved, and the acts were widespread and systemic in nature. Third, the acts did not occur within a few days. The acts that are mentioned between paragraphs 12 to 15 were occurred in a full of 2 months. In fact, even the international community, including many states, the European Union, and the United Nations Security Council, were aware of the situation. And as stated in paragraph 15 of the case facts, there were even images on social media. Considering all these, it is illogical to claim that the president and commander-in-chief of a country lacks actual knowledge. I will now move to the fourth element. Mr. Gravus failed to take the necessary and reasonable measures to prevent or repress the crime. Article 28 of the Rome Statute does not define the specific measures, but this court made such a determination. Accordingly, in order to prevent the commission of the crime, the superior is responsible to take disciplinary measures to prevent the commission of atrocities or to secure reports that the military actions were carried out in accordance with international law. And regarding the duty to repress the commission of the crime, the superior is responsible to stop the ongoing crimes and punish the forces. Mr. Gravus did not take any kind of measure to prevent or repress the commission of the crime. In the case facts, There is no single fact or evidence which can demonstrate the opposite. Mr. Gravus himself even called the decision of the Security Council a conspiracy against the national security of the Republic of Anatun, as can be seen in paragraph 16 of the case facts. But he did not take any kind of measures. I will now move to the fifth element. The crimes committed by the subordinates were resulted from Mr. Gravus's failure to exercise control. Even though Mr. Gravus had the effective authority and control over the subordinates, he failed to control their acts. His failure increased the risk of the commission of the crime. If he would exercise his duties properly, such as taking disciplinary measures, then we may face a totally different scenario. These measures are not hypothetical. They are reasonable measures which can be and shall be taken by the president. For the foregoing reasons, Your Honors, the OTP respectfully urges this court to find that there are reasonable grounds to believe that the court has jurisdiction. The case is admissible and Mr. Gravus is criminally responsible. Terminating the prosecution based on misplaced legal arguments, rhetorics, and distorted facts will not only harm justice, but it will also threaten international peace and security. At the 27th anniversary of the Srebrenica genocide, we pay tribute to all victims. This chamber should join the OTP and the United Nations Security Council in their commitment to international criminal justice, peace, and security. Never again. Not in Auschwitz, not in Srebrenica, not in Kasteria. This court shall put an end to impunity. Thank you.
Thank you very much, Counsel. And now we will continue to hear from defense team.
Good morning again, Madam President, Your Honors, may it please the court. The Office of the Prosecutor has asked this court to do three things. First, to find the case admissible, and in doing so, deprive the state of Hanatun of its right and its responsibility to carry out domestic criminal proceedings. Second, to find that the court has jurisdiction over 2 counts of genocide built upon dubious inference drawn from questionable evidence. And third, to find Mr. Gravus responsible for conduct committed beyond his control and knowledge. Now, in our submissions, we shall demonstrate that these assertions are inaccurate, unfounded, and ultimately unreasonable. And we will not resort to colorful rhetoric or distorted facts. We will simply show the court the law and the facts and leave the court to draw the conclusion that there are not reasonable grounds to believe the genocide had occurred or that Mr. Gravus was responsible for it. Turning to my first argument, we submit that this case is inadmissible pursuant to Article 17(1)(a) of the Rome Statute. Now, we accept the prosecution's submissions that the defense does have the burden of proof, as we are raising an issue of admissibility pursuant to Article 17. However, the prosecution is incorrect in determining the extent of the burden of proof. As we can see clearly from Article 17(1)(a) of the Rome Statute, there are 2 prongs to determining admissibility. First, if there are investigations, then that would render a case inadmissible. And that's the extent of the defense's burden of proof. If the prosecution is of the view that the case is still admissible, notwithstanding these national investigations, then the prosecution has the burden of proof to show that the state was unwilling or unable genuinely to carry out those proceedings. Now, we focus on the first limb and we submit before the court there are indeed national proceedings. Indeed, if the court will turn to fact 18, it is clear that there was a military court that established and that it is investigating the crimes committed in Kasteria. It is clearly fulfilling the same person, same conduct test for determining if the same case is being examined before the ICC. It is examining the same person. Clearly, Mr. Gravus is the focal point of these investigations, considering that the investigations examine conduct as of the 3rd of November, 2015, which is when he came to power pursuant to fact 6. And it is also examining substantially the same conduct. It is reviewing the same conduct that is the crimes committed in Kasteria. Therefore, the first limb of the admissibility test is fulfilled, and the court should find that this is inadmissible. Now, the prosecution has raised 5 arguments, claiming that the state of Hanatun is unable or unwilling genuinely to carry out proceedings. Now, we agree with the prosecution that the evidentiary standard for determining inability or unwillingness is one of evidence of a sufficient degree of specificity. That was held by this court in the Gaddafi admissibility decision, paragraph 54. This means that if the prosecution would cast aspersions on the state of Hanatun's unwillingness or inability to carry out proceedings, then the prosecution would need evidence of a sufficient degree of specificity and probative value to do so. Now, we will address the prosecution's 5 points. The first point was that the state was unwilling and unable because it failed to take investigative steps. Now, we have 2 points in response to this. First, Fact 18 makes it clear that investigative steps were indeed taken. Secondly, the standard for determining unwillingness or inability is not one of whether there is a failure to take investigative steps, but rather the tests laid out in Facts 17 and rather Article 17.2 and 17.3 of the Rome Statute. Considering that the court should apply in the first place its own statute pursuant to Article 21.1a of the Rome Statute, as opposed to standards proposed by the prosecution, we submit the court should adhere to its own statute in determining whether the state is unwilling or unable. And this takes me to my second point. The prosecution has argued that there is an inability on the part of the state of Hanatun because it has already endured its second coup in 6 years. However, we would refer the court to Article 17.3 of the Rome Statute, which states that a state is unable if it cannot obtain the accused, or alternatively, it cannot carry out proceedings against the accused. Now, it is very clear from the facts, Fact 17, Mr. Gravis was detained. He was placed under house arrest and eventually transferred to the court. Secondly, we know again from Fact 18, there were proceedings initiated by the military court. Therefore, it is clear that the state is able to carry out proceedings against the accused and able to detain them. The third point raised by the prosecution was that there was a lack of independence and impartiality because there was a coup. That and I will quote their opening statement, justice cannot be achieved by a military court established by a general against another one. However, we encourage the court to examine the facts, as it does not say that General Hitch was the one who established the military court. Therefore, again, there is no evidence to cast aspersions on the unwillingness of the state to carry out proceedings. The fourth point raised by the prosecution was that this court is not genuine in its investigations because it was established following international pressure. Now, following this line of reasoning, all courts established on the basis of international pressure by their very nature would not be willing or able genuinely to carry out proceedings. This would be manifestly absurd, Your Honors. The ICTR, the ICTY were established following international pressure. Should we then question the willingness and the ability of those tribunals to carry out proceedings? We submit that that would not hold true. The fifth and final point raised by the prosecution was that there were high-ranking military officers in Fact 18 who made assumptions as to the culpability of the accused. Now, this court faced a highly similar situation in the Al Sanusi case. And in paragraph 241, this court held that statements infringing the presumption of innocence would only affect the independence and impartiality of a tribunal if it came from the judicial authorities involved. Now, if we look to clarifications, paragraph 3, it is clear that these high-ranking military officers who made claims as to Mr. Gravis's culpability had no connection to the military court. Not that they had weak connection, not that they had tenuous connection, they had no connection, Your Honors. Therefore, we submit the court should find that this case is inadmissible and allow the state of Hanatun to carry out its national criminal proceedings. I shall now address questions of jurisdiction. And here we contest the court's material jurisdiction over the 2 counts of genocide submitted by the prosecution, namely genocide by killing under Article 6A of the Rome Statute, and genocide by deliberately inflicting certain conditions of life calculated to bring about the physical destruction of a group pursuant to Article 6C of the Rome Statute. Turning to the first crime, we submit that the constituent element of specific intent to destroy the group has not been fulfilled. And here we make 2 arguments. First, that the evidence upon which the prosecution relies should be declared inadmissible. This would be Mr. X's testimony as recorded by IHRD. And second, in any case, the totality of evidence does not point to a reasonable conclusion that there was genocidal intent. Turning to the first argument, we refer the court to its own evidence admissibility regime in Article 69, subparagraph 4 of the Rome Statute. In determining the admissibility of evidence, the court considers the probative value of that evidence and then weighs it against potential prejudice that item of evidence may cause to a fair trial. And of course, that was espoused by this court pursuant to the Katanga and Chui decision on the prosecutor's bar table motions, paragraph 14. Now, this item of evidence, Mr. X's testimony, is anonymous hearsay. And according to this court, in its 2019 Gbagbo majority opinion, paragraph 43, anonymous hearsay has no probative value. Now, this item of evidence also causes prejudice to a fair trial. It impinges on the accused's right to examine the witness pursuant to Article 67(1)(e) of the Rome Statute. And according to this court's Katanga and Chui decision, paragraph 42, this right is of fundamental importance to the fairness of the proceedings. Therefore, weighing the complete lack of probative value against the prejudice this item of evidence causes to the accused, we submit the court should find that this item of evidence is inadmissible and that the prosecution's claims that there was genocidal intent does not stand. Now, in any case, and this brings me to my second argument, we submit that the totality of evidence, even including this one item of evidence, would not point the court to the conclusion that there was genocidal intent, but instead that there was only discriminatory intent. And there is a key distinction between these two ideas. Discriminatory intent occurs when a person or a group of persons are targeted because of their membership to a particular group. Genocidal intent goes beyond that. It does involve the targeting of a group of persons because of their membership to a group, but it also has the added element of intent to destroy the group. And this distinction was held by the ICTY in its Cooperskitch trial chamber judgment, paragraph 636. Now, we submit that the prosecution submissions only evidence discriminatory intent. Again, only proof that these persons were targeted because of their membership to the group. We note the prosecution has raised 2 points in proving the genocidal intent under Article 6A of the Rome Statute. The first point was that there were subordinates who were chanting Casterians or cancer. According to the prosecution, this derogatory language is a factor in showing a genocidal intent. Now, we would submit before the court the Popovich trial chamber judgment, paragraph 1399. And I'll go ahead and read it out. As indicated before, while the use of derogatory language may be of relevance in relation to genocidal intent, it does not in and of itself evidence such intent. This is particularly the case given the culture within the VRS and the Zvornik Brigade in which such language was commonplace. Therefore, Your Honors, this only shows discriminatory intent. And we would concede that there was a discriminatory environment in Casteria. There was a clear anti-Casterian movement. But to say that this was genocide, to claim that there was intent to destroy the group, well, that still needs evidence, and we submit that there is none to support that. The second point the prosecution has raised was the release of Mr. X and the targeting of other Casterians. Again, Your Honors, this only shows that the Casterians were being targeted because of their membership to the group, and not necessarily that there was intent to destroy. Indeed, if I may cite the Cooperskitch trial chamber judgment, paragraph 636, discriminatory intent can take multifarious inhumane forms and manifest itself in a plurality of actions, including murder. However, until those actions escalate to intent to destroy the group, then we do not have genocidal intent. Therefore, we submit the court would not have material jurisdiction over the crime under Article 6A of the Rome Statute.
Counsel, excuse me for interrupting. Before you move on to another topic, I have a very brief question in relation to what you said to genocidal intent.
Yes, Your Honor.
And this is my question. Does, in your opinion, genocidal intent in Article 6 of the Rome Statute require that the perpetrator's actions were directed towards the destruction of the protected group or parts thereof? Or are other lesser forms of intent, for example, knowledge or eventual intent or the common law concept of recklessness also included in Article 6 of the Rome Statute?
Your Honor, we're of the view that only dolus specialis applies when there is that specific direct intent to wipe out the group. And of course, the term wipeout was used by the Gallich trial chamber judgment.
So in other words, yeah, excuse me, go ahead, please.
We would simply say that yes, direct intent is required.
So in other words, the so-called knowledge-based approach, as it was advocated by some well-known legal scholars, cannot be applied by this court. Is that right?
We would submit that the court should refrain from applying that standard because genocide is the crime of crimes, as held by the ICTR. It is perhaps the most serious allegation that can be brought against an accused. And therefore, it is important that we apply the incredibly stringent threshold in order to preserve the gravity of this crime.
Thank you. You may proceed.
Thank you, Your Honors. If I may, then I'll turn to the final count, the crime under Article 6C of the Rome Statute. Now, we would like to refer, before we enter a discussion of the genocidal intent, we refer the court to the 2007 Bosnian genocide case, paragraph 189, in which it stipulates, specific intent is to be distinguished from other reasons or motives the perpetrator may have. Great care must be taken in finding in the facts a sufficiently clear manifestation of that fact, of that intent, I apologize. Now, if we look to the facts, we'll find that the motivation behind the blockade was not one of genocide. From fact 15, it is clear that the reason why the blockade was set up was to prevent a danger of CNF attacks. And we know that there have been a series of attacks, as can be seen from fact 8 to 10. Furthermore, the state was not able to ameliorate the situation because of a deterioration of their economic situation, according to fact 16. And so these facts together do not point to the court that there was genocidal intent in this case. And we would also refer the court to the 2007 Bosnian genocide case, paragraphs 327 to 328, in which it states, and I'll quote the court directly, a siege, including the shelling of population centers and the cutting off of supplies of food and other essential goods, was another tactic used to force Muslims and ethnic Croatians to flee, but did not prove genocidal intent. Your Honors, was this an overzealous campaign and violent campaign to deal with a perceived security threat? Yes, it was. But is there sufficient evidence to show that there was genocidal intent? We submit that there wasn't. This concludes the submissions of the first speaker for the defense. Thank you for your attention.
Good morning, Madam President. Oh, excuse me. May I begin my submissions, Madam President?
Thank you. I would say you may proceed.
Thank you. Good morning, Madam President, Your Honors. May it please the court. My name is Nicole Binder, and on behalf of the defense, I will be responding to the prosecution's claims regarding Mr. Gravis's criminal responsibility for genocide. My submissions are threefold. Firstly, that Mr. Gravis did not have effective control over the NDS, SPG, and police. Secondly, that Mr. Gravis did not have actual knowledge of the criminal conduct of the NDS and SPG. And thirdly, that Mr. Gravis did not fail to fulfill any of his duties under Article 28A2 of the Rome Statute. Turning, if I may, to my first submission, namely that Mr. Gravis did not have effective control over the NDS, SPG, and police. Now, the prosecution has relied principally on the factors of Mr. Gravis's official position and his power to issue orders to demonstrate that he did, in fact, have effective control over all of his subordinates. However, as was held in the Cordic-Turquez judgment, paragraph 369, mere belonging to a chain of command is not sufficient to establish effective control. And furthermore, as was held in the Bemba judgment pursuant to Article 74, paragraph 183, general, albeit substantial influence is also insufficient to establish effective control. And we submit that that is all the prosecution has been able to demonstrate at this point. With this in mind, I would like to refer to paragraph 190 of the Bemba judgment pursuant to Article 74, which indicates some factors that prove a lack of effective control, namely subordinate noncompliance with orders issued by the accused and a weak or malfunctioning chain of command. As regards the first factor, in case facts 11, Mr. Gravis explicitly limited the scope of the counterterrorism measures to, under subparagraph A, the CNF and its Casterian supporters that posed a threat to Hanatune's public security, under subparagraph B, destructive social factions, and under subparagraph C, terrorist suspects. It is clear from the language of the counterterrorism orders, as well as the context in which they were issued, namely the aftermath of a horrific terrorist attack by the CNF that resulted in the immolation of 35 soldiers and the deaths of 3 civilians, as can be seen in case facts 10. Again, it is clear that Mr. Gravis explicitly limited the scope of the counterterrorism measures to address public security threats, and in particular, the CNF, that had proven itself to be such a public security threat. And Mr. Gravis further implicitly limited the scope of the counterterrorism measures in Exhibit 1 by implicitly excluding civilians from the scope of the counterterrorism measures. Despite these implicit and explicit orders, none of his subordinates complied with them. Assuming but not conceding the admissibility of Mr. X's witness testimony in case facts 13, the NDS and SPG shot 200 Castilian men dead for resisting arrest, kicked pregnant Castilian women in the stomach, and engaged in numerous other discriminatory acts targeting Castilian civilians who could hardly be considered to fall under the umbrella term of public security threats as required by the counterterrorism measures. The police department similarly did not comply with these orders by, for example, initiating the blockade of Castilia in case facts 15, or by trafficking 150 female Castilians into sexual slavery in case facts 14. And therefore we submit that Mr. Gravis was unable to ensure compliance with his orders. Now, as regards the second factor indicating a lack of effective control, namely a weak or malfunctioning chain of command, we do concede that there was indeed a chain of command in this case, as defined in paragraph 419 of the Hrdličková judgment. There was a hierarchical structure with Mr. Gravis at the top, setting general policy objectives to be carried down the chain for implementation. However, this chain was manifestly weak or malfunctioning simply because the general policy objectives he was setting, for example, in the counterterrorism measures, were not being implemented. And therefore we submit that it is unreasonable to conclude that Mr. Gravis had effective control over any of his subordinates. Turning, if I may, to my second submission, namely that Mr. Gravis did not have actual knowledge of the NDS and SPG's criminal conduct. The prosecution has conflated the two counts of genocide when addressing Mr. Gravis's actual knowledge of these counts. However, the prosecution has been unable to demonstrate that Mr. Gravis had actual knowledge of the criminal conduct of the NDS and SPG, namely the killing of the 200 Castilian men on the night of 15th July 2019. Actual knowledge cannot be presumed, but may only be inferred on the basis of relevant indicia indicating actual knowledge, as shown by paragraph 193 of the Bemba judgment pursuant to Article 74. And some factors indicating such knowledge include the number, type, scope, and time of the illegal acts, their widespread occurrence, and their notoriety. As regards the first factor, namely the number, type, scope, and time of the illegal acts, I would case facts 12, in which it is indicated that 200 Castilian men were shot dead for resisting arrest in the cities of Luz and Luzari on the night of 15th July 2019. Clearly, the number here is limited to the 200 men. In terms of type and scope of the crimes were limited to the killing of these men who resisted arrest in specifically the cities of Luz and Luzari. But most tellingly, these crimes only occurred on the night of 15th July 2019 and were not repeated on any other occasion. And as was held in the Hrdličková judgment, paragraph 248, an important indicia of knowledge includes the fact that the crimes were committed repeatedly. And here that is simply not the case as regards the killing of the Castilian men. Turning briefly to the widespread occurrence requirement, I would like to distinguish this case from that of the Karamara et al. Judgment, paragraph 1530, where the crimes were, quote, so widespread and public that it would have been impossible for the accused to be unaware of them, end quote. Here the crime was simply neither widespread nor public. As I have demonstrated, the killing of the 200 Castilian men was restricted to the night of 15th July 2019. And in terms of number, type, and scope of crimes, these again were too limited to qualify this killing as a widespread crime. And as regards the publicity requirement, this links into the notoriety requirement, as was described in paragraph 193 of the Bemba judgment pursuant to Article 74. And notoriety requires that the crimes were reported in media coverage of which the accused was aware. And here that is simply not the case. There is no evidence that the killing of the 200 Castilian men was reported in any media coverage of which Mr. Gravis would have been aware. And therefore we submit that Mr. Gravis simply did not have actual knowledge of the NDS and SPG's criminal conduct. Turning, if I may, to my third and final submission, namely that Mr. Gravis did not fail to discharge any of his duties under Article 28A2 of the Rome Statute. I will first address the duty to prevent. The prosecution has not addressed the knowledge requirement necessary to trigger this duty, namely the requirement that the superior knew or should have known of the impending commission of crimes by their subordinates, as was held by this court in the Bemba confirmation of charges decision, paragraph 437. Here, there is no evidence to suggest that Mr. Gravis knew or should have known of the impending commission of crimes by his subordinates, which, as was further elaborated on, again in the Bemba confirmation of charges decision, could have been indicated by past criminal behavior of subordinates. There is no evidence that such past criminal behavior existed, or indeed that Mr. Gravis could possibly have had actual knowledge or constructive knowledge that his subordinates were going to commit the crimes in question. And therefore, the duty to prevent never arose in the first place for Mr. Gravis. Turning now to the duty to repress and the subsidiary duty to refer. This duty arises again when the commander knew or should have known of the commission of crimes by their subordinates, as was held in the Bemba confirmation of charges decision, paragraph 435. Of course, I have demonstrated that Mr. Gravis did not have the actual knowledge of the NDS and SPG's criminal conduct. I have not addressed Mr. Gravis's knowledge or fulfillment of the should have known standard as regards the police's conduct, but ultimately this is of no consequence because a commander can only be held responsible for failing to take the necessary and reasonable measures to suppress the criminal conduct of their subordinates, where reasonable measures depends upon their degree of effective control at the time their duty arises, as was held in the Bemba confirmation of charges decision, paragraph 443. And here, Your Honors, Mr. Gravis simply did not have the effective control to take reasonable measures to discharge his duty to repress. And as was further held in the Bemba appeal judgment, paragraph 167, a commander cannot be expected to do the impossible. And here we submit it would have been impossible for Mr. Gravis to discharge his duty to repress. And as regards the duty to refer, I would like to refer to the Bemba appeal judgment, paragraph 170, in which the trial chamber held, and I quote, that abstract findings about what a commander might theoretically have done are unhelpful and problematic, not least because they're very difficult to disprove. And the trial chamber must specifically identify what a commander should have done in concreto. And here the prosecution has not demonstrated in concreto that Mr. Gravis could have referred the, Your Honors, I see that my time has elapsed. May I please briefly conclude my submissions?
Yes, you have 1 minute, please, to conclude.
Thank you, Madam President. The prosecution has not been able to demonstrate that Mr. Gravis could have taken any in concreto measures to either repress the commission of crimes by his subordinates or to refer the matter to a competent authority. Indeed, there is no evidence that such a competent authority exists to which Mr. Gravis could have referred the situation. And therefore, we submit that Mr. Gravis cannot possibly be said to have failed to fulfill his duties under Article 28A. And therefore, Mr. Gravis cannot be held responsible under Article 28A of the Rome Statute. This concludes the submissions of the defense. Thank you for your attention.
Thank you very much. Now the prosecution, if would like to use the 5 minutes for rebuttal, the floor is yours.
Thank you, Madam President. Madam President, Your Honors, in response to the arguments established by the Defense Counsel, the OTP will have the following points. First, paragraph 18 of the case facts states that an investigation will be completed in a month. But the case facts does not include any fact or evidence that the military court, in fact, started the investigation. The mere fact that the military court was established is not sufficient to claim that it started the investigation. That said, Hanatun itself is not raising this as an admissibility issue. And further, Hanatun had the time to conduct an investigation and a trial, but there is no information on any concrete steps that they have taken for the investigation. This court should not let this issue to further delay the course of justice. Second, Your Honors, the opposing counsel stated that international courts are also established by international pressure and presented this as an analogy to the international pressure leading the establishment of the military court in the present case. This is absurd. The Nuremberg Tribunal, the ICTY, the ICTR, the Special Tribunal for Lebanon, and the ICC were not created due to international pressure, but by international treaties and Security Council decisions. To say these courts and tribunals to say that these courts and tribunals have an analogy to the bogus military court in this case is absurd. It is rhetorics which the opposing counsel seems to disapprove. Similarly, the ICTY and ICTR are courts of primacy, not complementarity. They cannot be used as an example on a matter requiring the application of the principle of complementarity. Third, regarding the mens rea element of the crime of genocide, we would like to restate that the security forces had the genocidal intent, not the discriminatory intent. They had the intent to destroy Castrians in whole or in part. They called Castrians our cancer. They released Mr. X who belonged to the Hanu ethnicity. And as stated in the Nahimara case from the ICTR in paragraph 1037, statements that call people to take actions are accepted as about incitements and indicates the genocidal intent. And even the blockade itself is self-evident regarding this issue. Fourth, the acts that are mentioned between paragraphs 12 to 15 happened between 1 July and 30 September 2019 in a full of 2 months. The fact that the killing of 200 Castrian men at the same night is irrelevant. We would like to finish by restating and highlighting that the evidentiary standard in the present case is reasonable grounds. This does not require an absolute certainty. It only requires the existence of a reasonable conclusion. As this court also confirmed in its decision concerning the situation on initiation of investigation in the territory of Kenya, reasonable grounds test has the lowest threshold when compared with other evidentiary standards. This court shall put an end to impunity. As the enforcers of criminal justice, we, this court and the OTP, must ensure that the ones who are responsible are brought to justice and victims receive reparation. Unless I have further assistance to this pretrial chamber, this concludes our submission. Thank you.
Thank you very much. Now the defense has up to 5 minutes for rebuttal, should you wish.
Good afternoon again, Madam President, Your Honors. The defense will make 4 points in rebuttal in response to the points made by the prosecution. The first point made by the prosecution was that there is no evidence that there are actually investigations ongoing. However, it is clear from the wording of Fact 18, and I'll go ahead and read it out. The military court will complete its investigation in August 2022. This indicates that investigations, at the very least, have begun. Otherwise, there is no way that it could not be completed. They've also argued that no concrete investigative steps have been taken by Hanatu. However, what step can be more concrete than establishing a military court and carrying out investigations? We note from the Gaddafi admissibility decision, paragraph 55, that evidence in proving investigation means all material capable of proving that an investigation is ongoing. Therefore, we submit the establishment of the military court shows that there are investigations and that the court should find this case is inadmissible. Now, on the second point, we do not claim that the ICTY, the ICTR, that the other international tribunals do not have a legal basis in law. However, we cannot disregard the clear international outcry that surrounded the establishment of these tribunals. If it were not for international pressure surrounding the Rwandan genocide and the Srebrenica massacre and genocide, then these courts would not have been established. That is simply a matter of fact. But because it has been established on the basis of international pressure does not mean that these courts would not be genuine. Both sides, prosecution as well, have cited their jurisprudence. And this clearly shows that there are genuine proceedings can follow from a court established on the basis of international pressure. Now, we again caution the prosecution against calling the state unwilling without evidence. We know from the Yekatom appeal judgment, this is a very grave allegation to cast against the state, to claim that its national judiciary is incapable and incompetent to carry out judicial proceedings. And therefore, in the absence of evidence, we ask the court to find, again, that the state is able and willing to carry out proceedings and to leave the case to Hanatu. The third point the prosecution has raised was that this is still genocidal intent and not discriminatory intent. However, as we have addressed in the main body of our pleadings, the factors that they've mentioned, the calling of Castilians as cancer, the attacking of Castilians and the exclusion of Mr. X, this only shows that there was discriminatory intent and not genocidal intent. And finally, for the fourth point, we, again, highlighting the genocidal intent behind the first crime, this event took place on a single night and affected only 200 people. Does that mean it was not tragic? Of course it was tragic. Of course it is unfortunate. But the question is whether there was intent to wipe out the population. We've seen, for example, from the Galich trial chamber judgment, that there is a requirement that attacks be numerous, consistent, and intense. And even in that case, where there were 400 mortar and sniping shellings recorded in a single day, where there was a consistent attack against the civilian population, because it could not be ascertained that there was intent to wipe out the population, the court found there was not genocidal intent. And similarly, we submit the court should also find there is not genocidal intent. Now, as a closing remark, we do understand the evidentiary standard is reasonable grounds to believe, but that cannot absolve the prosecution of their requirement to base their arguments on evidence and upon the facts. We encourage and we see their enthusiasm for ending impunity as laudable, but again, without evidence, we cannot say that the evidentiary standard is fulfilled and that there is genocide and that Mr. Gravis should be held responsible for it. This closes the submissions for the defense. Thank you for your attention.
Thank you, counsel. I would like to thank both parties, and unless the bench has further questions, the bench now will take a break for deliberation, and we will be back with you as soon as we can. Thank you. Bench clerk, may I ask you, are we live? Can we proceed?
Yes, proceeding judge, you may continue the hearing.
Thank you. Welcome back. After the deliberation, the bench deliberated carefully, and though we were impressed by both teams, by your work, by your presentation, the judges unanimously decided that the winning team is the team of the defense. Congratulations, but congratulations to both teams, because both of you were excellent. And the bench will give you feedback just in a moment. We also would like to announce the two best speakers. The first best speaker, and the bench also decided unanimously, is Mr. Dylan Jess Adrian from the team of defense. Congratulations to you. And the second best speaker is the speaker of the first team, Prosecution, and it is Ms. Karsu. I would like to congratulate both of you. You were fantastic, and the bench now, bench members will give you more feedback to your performance. So maybe we can proceed with the order as written. If Judge Natalie Wistinghausen would start with the feedback.
Yes, well, congratulations to the four of you. This was really a fantastic performance. Of course, we had to make a choice, and we did unanimously, but the prosecution team was excellent as well. I have to say that I was really impressed of the coordinated way in which all of you presented the law and the facts and your knowledge of the jurisprudence. Very impressive. So all of that is something that none of us judges, I think, could do on the spot like you did. So really big congratulations for that. Maybe just a few words to the defense team that also I thought was the winning team here. I thought it was very good to really concentrate on the facts and the law. No emotions in your submissions. I think this is a very important thing. I also thought it was very smart to agree with some of the points the prosecution was making and to really concentrate on the points you wanted to make. I also found that at the end of the day, you had the better arguments. I don't know if it's due to the facts, but to me, it was your submissions were just more convincing. So thank you. This was, a very good moment. I enjoyed from The Hague, actually, and I can imagine that some of you, will be here sooner or later. So thank you very much.
Shall I go next, Madam President? Okay. Yes, also from my side, I really have to commend the presentations of both teams, of all four of you. I was extremely impressed by how structured actually your presentations were. It was easy to follow. So it was a narrow decision, but then we had to decide. And then again, as you already heard, the decision at the end was unanimous. Maybe you've already heard, Natalie hasn't said it explicitly, but we had the impression that the prosecution team was a little too emotional when it made its point and called, for the panel, for the judges to join them in establishing justice and so forth. I don't think that the judges need to be reminded of that. And at the end of the day, it's not the job of the prosecution, right? I mean, the judges are the organ that will eventually judge and establish justice, so to speak. You are sort of only to present the case. So that we didn't appreciate that sort of way of dealing with the judges. If you have a jury, that might be different. You have more room maybe for emotions in order to convince a lay person that were to judge, but with professional judges, you should really, in such a hearing in particular, concentrate on the law. I see that when you talk about the gravity of the case, you need also, to you need to talk a little bit about the emotions. I'm sorry, my computer is. Oh, Jesus. So, am I back on? You need to talk a little bit about emotions in order to establish the gravity of the case, but you know, you did this a little bit too much in our impression. And for the defense, the last speaker at the end, you of course realized that you were running out of time, and you know, the obvious way maybe to spare time was not to state so many authorities that. But you continued, you know, to fill in all the authorities that you had on your mind and that you had prepared, which was extremely impressive, of course. But and in the end, when you see time is running fast, you know, just throw out the arguments, and if there is a question about the authorities, you know, the judges can always come back. And if you speak very fast, it gets hard to follow. And you know, this is what you could have done better in just slowing down a little and then concentrate more on maybe more on the argument and not so much on the authorities. So those are a few observations from my point of view.
Thank you. May I ask Judge Korner if she would like to give a feedback? You are muted.
Microphone.
Can I join my fellow judges in congratulating both teams? I don't think I could possibly have developed that sort of length of argument in the time that was given to you. I think most of what has been said is something that I really want to endorse, and particularly speed. You can have the best argument in the world, but if the judge can't take it in, then it's completely wasted. And although you have live note certainly in the ICC, you won't have it in the courts in which you're appearing, or you're unlikely to, in most domestic courts, because it's very expensive. So the judge is taking notes. And if you go at great speed, then he's not going to take it in, or she's not going to take it in. Secondly, quoting authorities. Try and limit the number of authorities, particularly in a moot situation, because throwing authorities at the judges like that, most times you won't have enough time to quote the actual bit that you want, as was pointed out. And try and be selective, just pick a couple to demonstrate the point that you want to make, instead of throwing 3 or 4 or 5 in for each of the point. The judges will themselves, in any event, almost certainly, in real life, as I say, look it up themselves or have people assisting law clerks or whatever. But as I say, it was a close run thing, but in the end, I think what tipped it over was that the defense team didn't throw in the emotion quite so much. And final bit of feedback is, when you're giving an address, if you're going first, remember that the next team or the lawyer against you can always riposte. And just think, if I use emotion, what are the other side going to say? And here, the prosecution team got the answer from the defense. We are not going to use colorful rhetoric and distorted facts. And so that is always think, how is this going to be taken? Okay, but well done, both of you, or all of you rather.
Thank you so much. And Judge Barthe?
Yeah, now it's up to me. Thank you, Madam President. I can only reiterate what my colleagues just said. I was also very much impressed by your performance. I can say everybody did a very good job, and this is true for both the prosecution and the defense teams. I mean, given the fact that the case was not easy to handle and that it was rather challenging, I would say, in that it contained many legal and also factual issues, I can only congratulate you on your excellent performance and on your achievements during the last days and probably weeks. From a practitioner's or judge's point of view, I would like to give you the following feedback or practical or general advice. And first of all, and this is especially true for Ms. Kausu and Ms. Binder, or Binder, is it Binder? When you're addressing a court or a panel, be it as a prosecutor or defense counsel, and this was said before by my colleagues, speak slowly and clearly so that you can, or everyone in the courtroom can follow you, in particular, when you're talking about complex legal issues or factual issues. And this is not only for the judge's benefit, actually, or the public's benefit, but also in a real courtroom for the benefit of the interpreters and if there's any, a court reporter or the court reporter. Second, and you all did that, bring examples to help the judges and your audience to stay focused on the facts during your presentation. And third, avoid at all costs lengthy arguments with little or no relevance to the case, which is or should at least be self-evident. And this was not a problem at all today. You were all your arguments were all well prepared and straight to the point, of course. And finally, and this is my last recommendation, and perhaps the most important recommendation or advice I can give you, or would like to give you, familiarize yourself thoroughly with the facts of the case. And you all, as I said before, did that. We could see that during your presentation. Unfortunately, I have to say, you cannot always assume that everyone in the courtroom knows exactly what you're talking about, especially when you're talking too fast. People cannot follow you. Yeah, this is what I wanted to tell you. Again, many thanks for your excellent presentation. I wish you all the best for your future, and maybe, or hopefully, as Natalie von Wistinghausen said before, and I can join her in that, in your career in international criminal law in The Hague or elsewhere. Thank you.
Also, we would like to, if I may, Madam President. Thank you.
Yes. Before you, I would like to join my colleagues in your appreciation, and I would like to wish you all the best and keep your enthusiasm. That's probably one of the most important things in your journey, and wishing you all the best. Yes, Counsel, please proceed.
Thank you, Madam President, and excuse me for interrupting you. We would like to say thank you for judging this round and thank you for your valuable feedback. Also, we would like to congratulate team number 3. Thank you.
Yes, and very much in the same vein, we would thank the bench as well and the prosecution team.
Thank you. Congratulations to both of you again. And the court now adjourns.
The International Criminal Court is now adjourned. You may leave the courtroom. The judges thank you very much for taking your time, and I wish you